everybody. Welcome to day 2 of World Summit 2024 and to the very first workshop on all the things that you would want to know patenting intellectual property. We are thrilled to see all of you here on time and eager to learn the exciting yet a complex. We need to protect our property as well as our products. So we all know what incredible efforts goes in birthing your idea, putting your innovative solutions, and nurturing them into reality. We all know that we've interacted. In fact, we've interacted with many enterprises, more than 1,000 enterprises. And one thing that has continuously surfaced, and that is crucial, yet changing, the task of safeguarding those innovation. But fear not. Today, through this workshop, we'll meet an expert who will guide through the complex world of patents, trademarks, and everything in between. Allow me to introduce you to Shalini Menezes, founder of Menezes LLP, a former physicist with a knack for navigating the legal, financial intricacies of intellectual property. Over 15 years of experience in both US and Indian IP landscapes that have turned her into a sought-after advisor. Shalini, please feel free to introduce yourself the way you can.
Thank you, Felician, for the lovely introduction and for having me on Rise World Summit. I'm excited to be a part of your network and to be of assistance to entrepreneurs. So, today's uh, today's workshop is going to be more story oriented because I'll tell you, intellectual property by itself can be no matter how important it is to enterprises, but we are so busy with our product and our services and bringing it to market that intellectual property often takes a back seat. And kind of like going to the dentist, you don't want to go to your lawyer, you don't want to go to your IP lawyer, so it becomes one of these things that you put off till the very end, right? And uh, again, it is something that it's a complex being because intellectual property will start with intangibles, and then intangibles are broken into several other parts. But today we'll not go into any technical details or any legal details because those things can quickly turn a workshop very boring. So today what we're going to do is you're going to sit back, get yourself a hot beverage or cold beverage if you like, depending on what the weather is like where you are, and sit back and listen to stories. Now, all these stories have an underlying theme. The theme is that they had an intellectual property or multiple intellectual properties to protect. Some did and some didn't. So we'll see what happens once upon a time when there was an entrepreneur or there was a company, a startup, which had an intellectual property and one protected and one didn't. You remember the stories we used to tell and Aesop's fables that there were two brothers or three brothers, and two were very wasteful with the money that their father had given them, and one was very sharp, very shrewd. He protected his money. And what happened at the end of it? There was one brother who was out on the streets, and there were two brothers who were well to do and had a good life. So it's not all doomsday and it's not going to be all dark and scary, but we'll see what how things pan out for various technologies, for various companies that have intellectual property, and how they either protected or didn't protect, right? So it's only going to be a story time session today. You can sit back, you can relax, and at the end of the talk, I will take all your questions. Right. So we'll start at the very beginning. You always have to start with once upon a time. there were intangibles, right? And in industrial property, we have two kinds of intangibles. On one hand, you have copyright, which is a separate thing, and we will not be talking about copyrights today. And I'll tell you why, and we'll get it out of the way, correct? Copyright is to promote artists, to promote the creative and artistic works of creators, I should say. So any kind of literary, dramatic, musical, artistic works, cinematographic films, sound recordings, all of these get protected under copyright. And the reason we are not talking about copyright today, the reason we are talking about only industrial property today, which is not copyright, is because copyright is something that there is a moral right associated with it. And even if the term of copyright expires, right, even if it is usually life of the author plus 60 years or 70 years, depending on which jurisdiction, which country you're in. But even after that, the moral right in that artistic work continues for eternity, for perpetuity, which is the reason I cannot take a copy of Romeo and Juliet and say Romeo and Juliet by Shalini Menezes and get it published. Why? Because even if you're not a fan of Shakespeare, you know that Romeo and Juliet is his most famous work. You know it belongs to Shakespeare. So even though his copyright in that work has long expired, we cannot just take Shakespeare's work and put our name on it and publish it. So copyright we're going to set aside, and we're only going to be dealing with the industrial property. Now, in the industrial property, we have patents, which we've heard of them. Trademarks, India, we call it patents. In the US, we say patents. Design or design patents. And then there is geographical indication, there is trade secrets. So there are multiple things. What we will talk about, the stories we are going to be dealing with today are trademarks, trade secrets, patents, and design patents. Right. So let's have a quick one-line introduction about all of these. I don't have slides because I find often that when I have slides, people are reading the slides and not listening to me. So this is more of a way to keep you engaged and interact and ask me questions if you have any. You can put your questions in the chat and I'll be happy to answer them. So let's do a quick round of definitions so we can characters before we start the story. So we have trademarks, which you're all aware of, right? Even if you are an illiterate person or you are a child who has not learned to read and write yet, you are still aware of what is a trademark. Because you know, when you see a huge yellow M with a clown sitting outside on a bench or a clown standing there, you know what that place is selling. Correct? Burgers and fries and shakes, which is a reason. So that's a trademark. You go into a shop, you ask for a particular brand of toothpaste, for a particular brand of perfume or soap. You know you want to use Colgate or Meswak, and if it's not available, you come back home and you say, I will buy it on Amazon or I will try another day. Right? That is the power of a trademark. That's the power of branding. It is a way by which the service provider or the goods provider manages to convey to the consumer, to the audience, that these goods or these services originate from him, from his company or his office. And that is why nobody else is allowed to use the logo of an apple with a bite taken out of it, because it is somebody else's logo. Right? That is the reason you cannot use Just Do It on a bottle that you manufacture, right? Because it belongs to Nike. Right. So trademarks, I don't think I need to tell you why trademarks are important. They are important because of course, it creates a sense in your mind of what those goods or services are. It also creates a loyalty, right? You go to the shop, if your particular brand of soap or toothpaste is not available, you'll come back instead of buying something else, instead of settling for something else unless it's an emergency. So there's a brand loyalty, and that creates a goodwill for the business owner. And that goodwill is not usually seen, it's not in terms of money or cash lying around, but when that business is about to be sold or monetized or acquired, that's when that goodwill kicks in. That's when people say, okay, I will pay you this much above what your business is worth because you have goodwill. So trademark is extremely important to business owners. The second important player in this today's story session is patents. You have an invention or you have an innovation, right? It's not for discoveries. In fact, the Indian Patent Act gives you a list of things that cannot be patented. Anything outside of that can be patented. So usually it's for something that is novel, something that's brand new, something that is a step above what already exists. Okay, that step is called an inventive step. You can think of it in terms of a real step, right? Everything that exists in that field is at this level, and your invention has to be one step above it. Right? That's your inventive step. And third, it should be commercially applicable. It has to have industrial applicability. Because if something is only on paper, in theory, and it has no practical application, the protection of it is not usually granted. So, three things for patent: it has to be new, it has to have an inventive step, and it should have a commercial application. Right. Now, so that was trademarks, and then it was patents. Now, trademark is usually given to you for 10 years, and beyond 10 years, you can keep renewing it until and unless your business is still there. So, McDonald's, even if McDonald's exists 100 years into the future, every 10 years they can renew their trademark, and McDonald's brand can keep going for the next 100 years. Patents, not so much. Patents have a fixed lifetime of 20 years from the date of application, 20 years and done. And the third thing we're going to discuss, third and fourth thing that we're going to discuss, design patents and trade secrets. So design patents are kind of like patents, except that they're different in that patents protect what is a technical feature. Design protects what is an aesthetic feature, something that is ornamental, something that is about the look. So if you look at this cup, the way this cup keeps the liquid warm belongs to patent. It's a technical feature. The way the ear is rounded and the way the base is rounded, it gives it a particular aesthetic look. The way it has drawings done on it, that's an aesthetic feature. And there is, I know you can't see inside, but on the inside of the cup there is something written and there's something drawn. So that doesn't protect the liquid, it doesn't keep it hot, doesn't keep it warm, but that makes it look pretty. That goes into design application. Okay, and the last thing is trade secret. And we don't always need to take an invention and go and protect it and say, patenting can be an expensive affair. So we don't always have to do that in terms of protecting an invention. Sometimes it may be better to keep it a secret if the world thinks it's a secret. If the world doesn't know about it and it's a secret, then better to keep it as a secret and keep it under lock and key. But it has to bring you some kind of economic benefit. It has to actually be a secret. And third, you have to take all the steps to keep it a secret. Then it becomes a trade secret. That's it. So we've covered trademarks, patents, designs, and trade secrets. These are the main characters in today's stories, and we're going to see what happens when you don't treat these characters properly or when you treat these characters properly. Right? So we're going to start with 5 cases that we're going to do today. We're going to talk about Toyota Prius, Kodak, and Nokia. And we're going to talk about how they messed up their IP strategy. And then we're going to talk about Lego and Apple in the good light, but Apple also because it messed up slightly. And this is from current news. So we'll discuss on that slightly. Now, let's start with Toyota Prius. You're aware of Toyota Prius, right? It's a hybrid car in the US, and it is and it has a lot of fan following. I know I recently, even the other day, I met someone who said he has a Toyota Prius. So what happens when you don't look after? So now Toyota Prius was there for a long time in the US, right? In 2000, in 1990s, they had established their company in Japan, and in late 1990s they had launched a hybrid model car with the name Prius, and they had obtained trademark registrations in various countries except in India. Now, in 2001, Messrs. Prius Auto Industries Limited, they were manufacturing spare parts and accessories for cars in India starting in 2001, and they had registered the trademark Prius in 2002. Now, Toyota enters Indian market, comes to India and tries to file a trademark for Prius in late 2000s, right? They also filed an infringement suit before Delhi High Court, and uh, there was a lot of back and forth that went in terms of litigation. But uh, before that, I should tell you a little bit in trademark, right? There was usually a widespread reputation. It worked on reputation that, oh, the world knows about Prius, or the world knows about Philips shaver, that kind of thing. It's a well-known mark, and the mark has goodwill across territory and so on. But in this case, they brought in the concept of trans-border reputation. That means you have a reputation, you're well known, but in your country, you are not well known in my country. There is no universality thing going on here. So there was a problem that Toyota should have had the foresight that in India as well, but they didn't. And Prius Auto took advantage of that, and I don't know what their thinking was that they came up with the name Prius, but they filed for trademark before Toyota entered Indian market. And therein, Toyota lost the case. They lost a huge market because, Prius is a popular car and a lot of people, they like to drive it, but it's not there in India, right? So they lost that uh, entire market segment because they were not, didn't have their IP strategy in place. So now the court has held that the universality principle, that if you're well known in one country, you're well known in, if your reputation has spread, then you can be well known in other countries. Now that is only applicable to pharmaceutical industries because drugs are, they are pertinent to saving lives, and you don't want to be caught with using the drug name for something else and misleading the public. So pharmaceutical aside, for anything else, we don't have the universality principle anymore. So if you are planning, this was a case of Toyota not planning well. If you're planning on expanding in another market, if you're planning on growing, on scaling, the first thing you have to do is protect your mark, because the all of these characters that we talked about today, trademark, patent, design, except for trade secret, trademark, patent, and design, they are territorial in nature, meaning that if I want to enforce my mark in a particular region, I have to protect it there first. If I don't have protection in, say, United States, I cannot file a case there. I cannot file a suit there. Right? If I want to grow in a particular region and I want to stop others from using my mark in that region, I have to file for protection there. Right? So, first lesson, let's not make the mistake that Toyota did in terms of not protecting their mark before entering the market. A company like Toyota, this is would have hardly put a dent in their budget. It would have been a drop in the ocean of their budget, but they overlooked it. They were banking on universality, whereas the trans-border principle that kicked in, right? So this was a small case, and it seems like, it wasn't that big a deal, but we are a country of 1.3 billion people, And that's the kind of market that Toyota lost. Okay. Now, this was, you may think, okay, how big that was not that impactful of a story. But now let's see Kodak story, right? We are all familiar with Kodak. Their beautiful trademark where they say the word Kodak is from the sound the camera makes when you click it, Kodak. And it was found, it's an old company, 1988. It was its original avatar was the Eastman Kodak company, and it was a household name, right? It was the most famous name in the world of photography and videography. They revolutionized the photography and videography industry. There was a time where only huge companies could afford cameras for recording movies, right? And Kodak then changed it. They changed how people viewed it and made cameras affordable to every household, right? And their business model was beautiful. Their business model was, we will make the cameras affordable, but all the peripheral things associated with the camera, the rolls, the negatives, the developing, the photo paper. Remember, if any of you are from that generation where we used to use a manual camera, take pictures and develop them and wait in anticipation for the roll to get over and then develop it, and hope and pray that the pictures come back and most of them get developed. uh, but it used to be an exciting time to wait for it. And that developing cost, and then you buy an album and stuff, it used to be expensive, right? But you didn't think too much of it because the camera itself, the initial investment, the camera was affordable. So where is Kodak today? From 1988, and they survived 100 years. Where are they today? They failed. The reason they failed, that's what we are here to study. They had their business model is called, in business world, it's called razor and blades, right? Razor and blades means you make the razor inexpensive, affordable, but you charge heavily for the blades and the accompanying things that go with the razor. So they had a brilliant plan of razor and blades. Then they had an R&D team in place, obviously, because they were working with lenses and camera, but they didn't it was part of their marketing success, but they didn't take it forward. They didn't evolve. When photography evolved from analog to digital, Kodak did not make that jump. Okay. So there were a lot of things that Kodak did wrong. Everyone else was, changing, but Kodak chose to remain a dinosaur. And so to give you an example, from 1988 to 1968, Kodak owned 80% of the market. It had captured 80% of the market, right? And their films, printing sheets, their consumables were at a crazy margin. So they were essentially a money making machine. But now, as technology progressed, in 1975, digital cameras came into place. The first engineer who came up with the digital camera, he was an electrical engineer at Kodak. He was in-house. He showed a digital camera, and when he showed the digital camera to Kodak, his bosses said, "Oh, that's cute, but don't tell anyone about it. That's how you shoot yourself in the foot. Don't be an embarrassment." You know what, Steven Sasson, that was his name. You know what he did? He took the digital camera and he took it to Fuji or Sony. So Kodak said, digital cameras are not going to be popular because film and paper is right now popular. And if you don't require these for photography, how are things going to work? Digital is never going to catch up. People will come back to film and paper film and paper. By then, Fuji, Sony, Nikon, all of these jumped into the digital era. And production and sales of digital cameras shot through the roof. Where was Kodak in all of this? Nowhere in the race, because they were still digging their feet in the ground saying, nope, not going to happen. People are going to come back to film cameras. That was their first and biggest mistake. The ignorance of new technology, the putting blinders on and saying this new technology doesn't exist or it's not going to last long, people are going to come back, not adapting, not evolving with the changing market, not evolving with the changing world. That started Kodak's descent into bankruptcy. Now, the biggest cause of Kodak's failure was that, yeah, digital cameras were becoming popular, but Kodak was arguing with people, was arguing with Fuji that people are going to love a printed image, people are going to come back, they're always going to pick print over digital image. Now, by then, Fuji and all of the other people who had gone into digital were growing by leaps and bounds, but Kodak was refusing to take any kind of criticism or feedback or check with what the market wants, with what the media wants. Right? Kodak is still was still trying to convince youngsters that look, film cameras are better than digital. They lost 10 years in this, trying to convince people that digital is not going to happen. During this time, people realized, hey, digital is cheaper than film photography because, and the image quality is better and sharper, right? And look at where we are today. We carry a camera around in our phones. It's thanks to digital camera. With all this, Kodak did not have a strategy in place. It did not keep up with R&D. It did not keep up with market requirements. It did not keep up with change in technology, right? Now, rapidly changing technology, market needs something else. Whatever Kodak's strategy was at that point that we should convince people was no longer effective. What did Kodak do? It could have used up all its funds to evolve, to come up with a better product, right? Because, of course, with minds like Kodak had, and with the kind of equipment that they had, there is no way that they could not have come up with something better. But what Kodak did, it said, no, no, people are going to come back. And it spent 10 years acquiring all the small companies that were all the small film companies, right? They spent all of that money acquiring those companies that it could have put into developing their own digital camera. 10 years later, by the time Kodak realized that digital cameras are here to stay and film cameras are out, it's passé, it was too late. Fuji and Sony had already established themselves in the market. 120 years later, Kodak could no longer keep up with them. And in 2004, Kodak laid off about a fifth of their workforce. They announced that they're going to stop selling traditional film cameras, and their stock price, by the time it was 2011, their stock price hit an all-time low. They were in pennies, I think they were at half a dollar or something. And they had used up all their resources and cash reserves by then, right? It took 10 years for them. So where is Kodak today? Right, 1988, it was known as the Eastman Kodak Company. Look at the kind of fan following it had. Look at the kind of cameras it had. Look at their business strategy for film cameras. And 150 years later, where are we? 120 years later, right? We have gone bankrupt. And Kodak, what could Kodak have done? It's food for thought. It is that it knew that people are evolving. It knew the technology is evolving. Kodak was aware of who their competitors were. They even had an in-house engineer develop the first digital camera, and they overlooked all of that because they were not ready to keep up with the times. So oftentimes you will see that you have come up with a technology, or you have come up with a business plan, or a product or service that you think the market needs. But the lesson we learn from Kodak is that when you see that there is no longer any need for that product in the market because there has been a disruption, it's time to change. It's time to keep up with the Joneses, so to say, right? You remember the magnetic tape audio cassettes, right? How quickly have we gone from an LP long playing record to the magnetic tapes, audio cassettes, to the one you used to put your pencil in and wind and rewind and forward it, to compact discs, to MP modify, right? Which is so different. We couldn't have envisioned, the ones we of the generation where we had the magnetic tapes could not have envisioned that we are going to be listening to music from a device that also houses our cameras. But look at how things have changed. Now, if the makers of music had dug their feet in saying, no, we are still going to record audio tapes, audio cassettes, where would that industry be? Where would we be? Right? So you have to keep up with the times. You have to keep up with what the market, where the market is at. You have to keep up with the new technologies, and you have to be able to pivot. You have to be able to change, even if you have a patent in that thing. So this was the problem with Kodak. They said we have all of this equipment, and people are going to come back. Don't pretend to know that you know what the future is going to look like, right? We don't know. So accept the change and be ready to innovate. Innovation does not always have to be the at the level of Einstein and Newton, that you need a big lab and test tubes and gears turning. It can be in small things. It can be in just changing your mindset and going and pivoting with what you already have. Right. So this was Kodak's tragedy. Right. I'm going to tell you one more such a story, and then we'll move on to happier times. Okay. How I don't know how many of you like Harry Potter, but if you of the story of the meme that says that Voldemort's eighth Horcrux was in a Nokia phone. You know which Nokia phone I'm talking about, the one where the charge lasts for several days. You know which one I'm talking about, right? Okay, so what happened to Nokia? Nokia was a tech giant, right? We had everyone had a Nokia phone in 2000s when I had just come back to India from the US for the first time, and everyone in those days, even the bhajiwala, was walking around with a Nokia phone. So let's see what Nokia's story was. Even though Nokia was a tech giant at some point, when it started out, it was a paper manufacturing company. It was a pulp mill, right? It was in Finland. Now, then it partnered with local companies, Finnish Cable Works, and so on, and eventually it formed Nokia Corporation. That's the Nokia Corporation that we know today. So it started making mobile phones. It became a major player in the electronics industry, and at one point in 2000s, everyone had a Nokia phone, I think. So Nokia phone, it was a golden era, right? That 2000, 2002, 2005, it was a golden era for Nokia. They had made nearly $50 billion in sales in 2007. That was their most profitable year. Now, sadly, unfortunately, that iPhone was released. Okay. Now, no one saw the future, that neither Nokia nor Apple, no one could foresee what iPhone would do to the market, right? The same thing that CD players did to the tape market, the same thing that Spotify did to the iPod market, is what Apple iPhone did to the telecom market. Now, Nokia was fairly successful, reasonably successful until 2010. And then what happened? There were a variety of things that happened. In 2010, everyone else had evolved into touchscreen, into fancier phones, right? To keep up with Apple. Motorola, Samsung, Huawei, they all kept evolving. Nokia did the same thing that Kodak did. It made the same mistake that Kodak did, right? Their Nokia's operating system was also an obsolete one. It was not as fancy as iPhone and operating system. And Nokia, Nokia did not have the same user. So they did not evolve with iPhone. They didn't expect iPhone to be such a big hit. They did not keep up with iPhone, while Samsung, Huawei, and all the others did keep up with iPhone. By the time Nokia decided, oh, we want to get into the smartphone market, instead of doing fancy things with Android, Nokia decided to go with Microsoft. And we all struggled with Windows. Nokia and Microsoft's Windows Operating 7 was a big failure, right? It was disastrous for the company. So Nokia ended up going in loss, right? For the first time in 2 decades, Nokia just went into loss. Now, this was, and honestly, they never really came back from it. It wasn't the end for Nokia. They lost $8 billion. And by the time Nokia, and then Nokia mobile phones could still be sold again, but it's not that it never came to its earlier glory. So now Nokia still exists. Where is it? It's got a recent rebrand. It focuses now on telecommunication and digitalization. They still sell phones under Nokia name, but it's not that fancy. It's not that great. Nokia, right? So what happens in these cases? What could Nokia have done? Right? In the previous case, in Kodak as well as in Nokia, the problem is that they were very smug. They were very content in their popularity, in their success, and they thought that nothing can touch us. But the startup world, the world of entrepreneurs and corporates, the world of innovators is not like that. You cannot afford to be complacent. You have a product, you have protected it with IP, well done you. Or as in the case of Toyota, you've not protected with IP, so that's even worse. But at least these guys had protected it, but they didn't evolve. They didn't go on to the next step. So you have to accept that at some point your technology is going to be obsolete. If you remember the earliest television screens, you remember the cathode ray tube, right? We used to have one called by a company called Dianora in our house. Now, from that cathode ray tube to LED, to LCD, to plasma screens, to 4K screens, right? Look at where we've come. And now I don't know who even goes and buys television. Now we all watch it on our mobiles or on our tablets, right? So look at how the television industry has evolved. If companies like Philips and Sony had dug their feet in the ground saying no, cathode ray tube television screens are the best and people are going to come back to it and nobody is going to go in for a thin screen or an LED or LCD or plasma, and we are going to stick with this, imagine where we would be. Correct? So we have to understand from these stories that it is, of course, it is good to innovate, but it is also good to pivot. It's good to keep up with what's happening in the outside world, right? And just maybe, give them the benefit of doubt that they may actually be in the right and we may be in the wrong, and we should also evolve with them, right? So, if you have any questions relating to these stories till now, you can put it in the comment section. Okay, now the next story is not going to be so doomsday. It's going to be a happy ending, right? Um, if you, I'm talking about Lego bricks, right? Where does Lego come? It comes from Denmark, right? You may think it's this tiny block of plastic. It's been produced in tens of billions of Lego factories since that time, since 1958. But that little brick, right? If you hurt your foot on that in the middle of the night while walking through your child's room, you know nothing hurts more than that. But that little brick is it's much more than what that branded, colored, it's molded, and it's a piece of polymer ultimately. But it has, and nobody till date, I haven't seen another company have their IP protection fundamentals in place like Lego does. Right? Lego comes from the Danish word legot, which means let's play. So it's beautiful, right? Their name itself means let's play. So it didn't start off as a polymer brick. It actually was it was a Home Depot kind of shop where the owner was his name was Ole Kirk Christiansen, and he used to run a woodworking shop. He used to sell items for household requirements such as ladders, step stools, and so on. Now, one day that factory or that his warehouse caught fire, and his all his inventory went in that. It got burnt. So he started making wooden toys. He started making these blocks called with wooden toys, which he used to call leg god. Oh, sorry, it means let's play well, not let's play. Play well. And years later, and okay, so this was 1916. But by 1950s, by 1940s, 1950s, with the Industrial Revolution, plastic came into play. Plastic became common. Uh, Polymer became easily available. Lot more, it was cheaper to manufacture, easier to acquire, lighter to transport, and you could color it brightly with beautiful colors, which you couldn't do with wood. You were limited in your colors. So Curtin blocks into plastic bricks, which he called Lego. Now, none before that, right? When you had the wooden work and all, none of them involved um, interlacing or interlocking of bricks like Lego does, right? But with plastic, that became possible. Now, from this point, from the time that Industrial Revolution happened post the war, and I'm talking in late 40s, early 50s, uh, Kirk Christiansen he purchased a plastic injection molding machine, Lego toys that he has been making since 1916. Now, how did that? So we think, okay, that was a first. How we see Lego today how Lego revamped itself, reshaped itself in the late 40s, right, after the war. Now, he also at that time he found a set of plastic building blocks by a British manufacturer called self-locking building blocks. So there were no Danish patents. Kirk Christiansen filed a patent for these automatic binding bricks. Right? The first type of Lego brick that was there, and it was, of course, he had copied it at that point. But quickly, within a decade, Lego became far more superior to anything that the original uh, British prototype was. Now, uh, we had by this time Kirk Christiansen had died, so now we had um, Kirk Christiansen's son, Gottfried. Now, Gottfried noticed that these bricks, those bricks that they were manufacturing, which was a copy of the British guys' bricks, they could easily be knocked over. So he started making these internal binding, the stud and tube coupling system that Lego has. It has little studs, and then you press it on top of that. So this innovation came about in 1955. So it brings me back to my point that I was making, that innovation does not have to be at the level of a huge lab with smoldering test tubes and gears and pulleys and all sorts of fancy things that we see in the movies. Innovation, this was innovation at its finest, right? But at such a small level, you're taking kiddie blocks and you notice that they don't interlock properly, and you say, okay, what can make this lock properly? I'm going to make a stud and tube coupling system. Now, at the same time, the other innovation that Kirk Christiansen's son Gottfried he found out, was that toy manufacturers, they kept making toys that sold once rather than make like a whole family around it, like an interrelated set. Like your Barbie. With Barbie, you have Ken and Barbie's sister, and Barbie in India, Barbie in swimming, Barbie as homemaker, all sorts of things. So you have a whole story around it, right? So in the same way, Gottfried then decided to create a whole ecosystem around his Lego bricks. He created a town, right? It was called a town plan. You could have cars and trees and playmat. You could have figures. You could have little houses. You could build all these things. And he started creating all these sets, and all of these were protected with intellectual property, right? So all of these innovations he was doing, from the wooden block to plastic molded uh, blocks, to the interlocking system, to all of these system of play that he created, the towns, he protected both the original Christiansen as well as son Gottfried. They protected it at every level, right? Now, that change that he made, the system of play, is what 16 and 100 years later, right, we still have intellectual property by Lego that still exists. How? Because every time they make a new thing, every time, if you see a Batman movie comes out, there's Lego Batman. Harry Potter movie comes out, there is Harry Potter Lego. There is Toy Story comes out, there is Toy Story Lego. So there is a Lego system that comes out with they tie up with movie franchises, and they protect that intellectual property. So it again goes back into subsisting into an existing intellectual property. And the whole reason Lego has managed to survive this long is because you can use the same brick to make an airport, you can use it to make a fire station, you can use it to make a house. The brick is a brick, right? That connectability and that exchangeability, that this brick will fit with any brick, that standardization is what Lego nailed it, right? A lot of people don't do that, and they don't offer a standardization, and that becomes a problem. But Lego had the bigger picture in mind. Now, when you look at it, it looks like, okay, it's just a piece of plastic. But if you actually put it in the Lego world, in the system of play, it connects to other bricks. Uh, it connects to other bricks. It also connects to our children because they get stuck to it. So what has Lego done? Of course, it's trademark. It's filed in almost every country. We have patents, right? The earliest patent for Lego brick was in 1958. In the US, he got a patent in 1961 for a toy building brick. But we have then patent portfolios in Europe, North America, Australasia, all of it, right? So even now, if you go to the market, if you go to a bookstore or a toy store, you're going to see a Lego set with the latest franchise on it. Now, it was not just this, right? There were other companies that tried to copy Lego. There was a company called Tyco, which began to make super block line of bricks. And Tyco did unfair things where it made if you bought a Lego set, you know how expensive it is. Tyco brought the prices for the interconnecting bricks to very low prices, and Lego because everyone already knew what Lego was, so they didn't have to spend on advertising except that theirs was cheaper. But Lego sued Tyco. They failed in some countries, but sometimes in some claims they succeeded, in some they failed. But look at Lego's vision. Look at Lego's, they could have, or that, hey, look, we've got a patent, we don't need to do anything else. but they can. We're back, and I was telling you about Lego, about Tyco being sued by Lego. Lego won some of the claims, they lost some of the claims. There were some other companies also that did not, that, you know, that tried to copy Lego. They were called Mega Blocks. It was a Canadian company. And again, Lego sued them and won the case. So Lego had this, as still has, this brilliant strategy where they could have been like no, like Kodak, and dug their feet in the ground and say that no, we are not going to evolve. Okay, where am I? Okay. Where they said that we are not going to evolve, we are going to continue making building blocks, wooden blocks. But they didn't. They went from wooden blocks to plastic injected heat molded blocks. They went from there to interlocking blocks. They went from there to making a whole town. They went from there with tying up with franchises, popular franchises, and that is how Lego still has kept its intellectual property intact. There are multiple copyrights, design patents, actual patents that are existing in various parts of the world. And I think it's at this point, its intellectual property portfolio is still more than 70 protections. So that kind of long-term thinking, right? Your 1916 to 2016, you could have easily become obsolete given how children's um, method of play has evolved, right? You hardly see any children who are playing these days in the sense that we used to play when we were young. But Lego has still managed to capture the market, still managed to maintain a stronghold in the market without losing sight of how to evolve, without keeping their feet in the past. So that's a brilliant bit of evolving and pivoting by Lego, which I wish Kodak had learned its lesson from. Now, in addition to this, right, I have one more story, success story. But with that success story, I also have a little bit of after story where things didn't go quite right. And you will agree with me that Apple is a brilliant intellectual property plan in the sense, and this is evident, right? Because we have sorry, Apple has a brilliant IP plan, and this is evident how? Because we know that people stand in line even today to upgrade from Apple 11 to 12, 12 to 13, and I don't know what. I used to have an Apple 5S, and after that I stopped upgrading and I stopped buying new iPhones because you know you know how iPhones go. So Apple is one another company other than Lego. So if Lego has a strong intellectual property strategy and portfolio in mechanical and non-technical area, Apple enjoys that same position in the technical field, right? And it has been this intellectual property strategy of Apple has been instrumental in protecting the company's innovation and preventing unauthorized use of its technology. So if you open any kind of news sites, every other day you're going to see Apple versus Samsung, Apple versus Huawei. Apple is constantly in battle with other technology giants. And the reason for this is because they have to keep their IP protected. So the first way you can learn from Apple is have a watertight, robust non-disclosure agreement. Apple uses NDAs to protect all kinds of sensitive information, new product design, technology, music that goes into Apple, what have you, from being shared with competitors or unauthorized parties. These agreements, what they do is they legally bind you, the employees, the contractors, the business partners, to keep the confidential information secret. As recent as 2023, there were some employees of Apple who left Apple and moved to another company and and were Apple filed a trade secret infringement suit against them. So look at the sorry, granular level at which Apple keeps tabs on its employees, where they're aware of individual employees leaking trade secret. The next thing is patent portfolio management. Right? Take care of your patent portfolio. Apple has a significant patent portfolio that covers multiple aspects of its products, designs, technology, and the company actively files for patents too, right? If you look online today on either googlepatents.com or on Justia, or there's a Patent Lens, there is a website called Patent Lens, you will see on a weekly basis, Apple is filing patents, right? And it uses this complex system of patent cross-licensing to manage intellectual property rights. So cross-licensing is a brilliant way uh, to have a larger portfolio without spending all that money. What does it mean? Let's say I have a beach house, and kind of do I live close to the beach in Goa, and you have a house in the mountains. So rather than me buying another house in the mountains and you buying another house by the beach, what we do is we give each other whenever you want, right? And you pay me this much rent, and I can come stay in your mountain house and I pay you this much rent. And now we can both enjoy two houses for the price of one. It works in a similar way, a little more complicated, of course. I'm oversimplifying things, but the idea is by and large this, that two companies that have patents that the other one would use, instead of spending money on reinventing the wheel and then infringing on someone's patents and spending time and money and other resources in fighting, works beautifully. Apple, as I already said, trade secret protection. Apple takes extensive measures to protect its trade secret, especially manufacturing processes, design techniques, software algorithms. They use non-disclosure agreement. If you remember, for trade secret, I told you have to keep it under lock and key. So they use secure facilities, other security measures to prevent leakage of sensitive information and to prevent unauthorized access. Apple also a bit of a bully, but they take aggressive legal action, right? They don't hesitate to take legal action against companies or individuals who infringe on their IP rights. So the company has always been successful in enforcing its intellectual property rights through lawsuits and settlements, which helps gives it its edge, right? Competitive edge. The other way Apple also protects itself is called as defensive patent acquisition. What does that mean? It means that before before falling into that, coming to that, we always say we'll cross that bridge when we come to it. But before they come to that bridge, Apple acquires patents. So it's called a defensive patent strategies. It buys patents off from other companies to prevent its competitors from making use of technology or the patented technologies against it. So before they go and fall into the pit, they buy all the material and make sure that they don't fall into that trap. They collaborate with their suppliers, with their vendors to protect their IP. The main thing Apple does is it prevents, if you've heard of non-practicing entity or patent trolling. Right? Patent trolls, exactly like how trolls sound in Harry Potter, they roam around with a club in the bathroom, not those kind of trolls, but they buy a lot of patents and they look around for people who are even remotely stepping on their toes, and then they file cases. That's all trolls do. They don't do research and development. They just buy patents and they stop others from using it. That's how they make their money. They make them sign expensive licensing agreements. So Apple takes steps to prevent patent trolls. We don't have patent trolls in India yet, thankfully. It's a situation that the US has to deal with, but Apple takes care to avoid patent trolls, and with patent trolls comes frivolous lawsuit. So Apple avoids that, maintains its reputation for innovation. It starts from scratch. It has a continual IP education. They train their teams, they train their employees and their partners in IP protection, importance of confidentiality, in terms of innovating, in terms of handling sensitive information, in terms of responsibility when related to sensitive information. So Apple keeps everyone on their toes where the training is, everyone is up to date where training is concerned. Then, of course, we have strategic partnership that Apple enters into with other companies to develop and protect intellectual property. And by collaborating with these like-minded firms, by collaborating with people with whom they share ethos, Apple can share the financial and legal burden of IP protection, right? Then it's not all in Apple's court. And finally, if you have used Apple products, and my computer is a Mac right now, you know how they continuously innovate, right? Their success in IP protection is is second to none, right? The company invests heavily in research and development. They're constantly pushing the boundaries of innovation, of technology, design, intellectual property, and by staying ahead of the competition, right? That's what we know Apple for. That's what we love Apple for. So that's how Apple can protect its IP rights and maintain a competitive edge. I don't have a sob story here where Apple is concerned. The reason is that Apple does such a good job that, Apple does such a fantastic job that I don't have any bones to pick with it. Unless if you have been following the news, you know what I'm talking about, right? I'm talking about Apple versus Massimo, which was on December 24th, Christmas Eve. Apple pulled out two of its newest smartphone watches from store shelves. Why? Because they lost a patent dispute over whether it copied another company's technology, and that other company was Massimo. So Apple had this. We all know Apple watches, right? So it had a new version of its watch. It was a Series 9 and Ultra 2 version. Massimo is a med tech company that sued Apple, saying that Apple has infringed on my patent for a blood oxygen sensor that can read someone's pulse, because the latest Apple phone had that it could read your pulse, and because of your blood oxygen sensor. So Apple, of course, denied that allegation, but because it was found infringing, Apple pulled its watches, and it was huge, right? It was like holiday season in the US. It's a big deal. But Christmas Eve, it took off all the Apple watches, those Series 9 and Ultra 2, from the shelves. So what a little background to it: in October, the International Trade Commission in the US held that Apple had violated Massimo's patents for that blood oxygen sensor, which Apple has been including in most of its smartphone watches since 2020. If you have an Apple Watch, I don't. The commission then issued an import ban on that Series 9 and Ultra 2. That ban was supposed to start on December 26th, but Apple took action earlier. Now, the commission also advises the White House, and Apple has been fighting the commission's ruling. And, the recent development is that the tribunal's decision that has been upheld, that is Massimo, it's in favor of Massimo. Now, Massimo is a publicly traded company in California that sells patient monitoring devices. So blood oxygen sensor would have been quite top on their list. So there was an Apple analyst who said that it had a small impact on sales. But, what could Apple have done to prevent this? So I'm going to collect all these questions, right? We have Toyota Prius, who did not, how much does it cost to file a trademark in India? And now it is about 15,000. In those days, it would have been about 5,000, right? To save 5,000 rupees, they didn't file a trademark in India. What did Kodak do? What did Nokia do? What did Lego do right? What did Apple do right? And what did Apple do wrong? Right? So we have all of these case studies in front of us. And what these case studies, the reason I brought out all these, so I could have done a talk where I, go into the basics of trademarks, the basics of patents, the basics of copyrights and designs, and put you all to sleep here, right? But the reason I brought these stories is, of course, you may say that, hey, these are all big companies. What do they have to do with a small entrepreneur like me? The reason I brought these stories today to share with you is that I work with some big companies. I work largely with smaller companies, with individual inventors. And I find that there is a lot we can learn from these stories, from the good and the bad as well, right? There are missed opportunities. Toyota missed an opportunity in India to bring Prius to 1.3 billion, to a market of 1.3 billion. If I take even 1% of that, that's still a huge number. They were not thinking, I don't know. How Lego successfully evolved from selling wooden household appliances to um, to reinventing themselves into where they are still relevant in a global market from a small village in Denmark, that requires a different kind of thinking, to a giant like Kodak, which was a huge company. At one point, it was a king. It was reigning over everyone, right? To where it turned to dust. To Nokia, who again, 50 billion, they reported $50 billion in 1 year, and then they went to practically none, right? Where is Nokia these days? So the the reason I brought these stories is that the importance of prioritizing intellectual property protection, learning what is IP, learning the basics of IP. You can open any book, you can go to the internet, you can learn about it. But the importance of it can only be learned through stories, through these case studies, right? What happens when you don't prioritize? And I have a lot of clients who come in and say that, hey, I didn't file a trademark for this and now someone else is doing it. Hey, I didn't file a patent for this, but that was 6 years ago and now they're making a profit and I didn't file a patent in my name. Now what can I do? 6 years later, sadly, there is nothing much you can do, right? Because I told you, if you remember, that a huge part of patenting, one of the requirements for patenting is it has to be brand new, novelty, right? 6 years later, the novelty is destroyed. If you haven't reinvented yourself, so even if you have a patent for something that you believe is important, right? But that technology has changed and now what you have built is obsolete. How can you use that, repurpose that, or make it or come up with something better, come up with a new improvement? Don't just hang on to the past saying, hey, I put money in this, I have invested in this, and therefore this patent is my baby, I'm going to keep hanging on to it. No. World has moved on, move on with the world. Startups have to stay ahead of market trends. That's a huge part of what you have to offer, right? You're small, you are gritty, you are ready to fight, you're scrappy. Use that to your advantage. Stay ahead of market trends, figure out what your customers want, and conduct surveys. Don't say people are going to come to me. Go to people, find out what their requirements are. Protect your brand and intellectual property. And anytime you see that you're failing or it's not working out, consider alternate revenue streams beyond your core business, right? Because something can be repurposed for something else. I'll tell you another story. It has nothing to do with IP. But it's an interesting story. There was a judge, and then two parties are fighting a case where this party was importing steel from Japan to make bicycle wheels. Now, apart from, and there was some tax imposed on the steel that they import to make bicycle wheels. The tax specifically said it is for when the metal is being used to make the wheels, the rim of the wheel. Now, when they with the scrap metal that was there, this small company started making, of course they were making the rims for the bicycle wheels. They started making vessels, steel vessels, glass and cups and so on. The uh, tax levying authority said, you cannot make all of these things. You cannot make cups and vessels and steel utensils, because that metal was being imported for making rims of bicycle wheels. So the attorney, the lawyer arguing for the company that was making all those utensils, was trying to convince the judge, and the judge was like, I'm not convinced. And the judge had his pencil, he was chewing on the tip of his pen or pencil. So this attorney asked the judge, what are you doing? He says, I'm chomping on the edge of my pencil. He says, why are you doing that? He says, I'm thinking. So the attorney says, but the pencil is for writing, right? When you bought it, it was for writing. Therefore, can I make a rule that you cannot chew on the end of it to think? And the judge realized what he was saying, and he understood that the absurdity of that suit, of that litigation, and threw it out of the window. But it drives home this point that you should consider alternate revenue streams. If magnetic tape, if the tape audio player has changed and gone on to CD player, find something else to do with that magnetic tape, right? Consider alternate revenue stream beyond your core business. And by following all of these practices, right? First, identify your IP, strategize. I know it seems when you're a startup, it seems like it's an expensive proposition. And why should I need to pay for an IP lawyer right now? It doesn't make sense. It doesn't fit in my budget. I've not planned for it. I agree with all your points. But if you don't protect it, someone else is going to protect it. Think of your intellectual property as a piece of land, right? If you don't build a fence, you're going to have squatters. You're going to have trespassers. You have to put a board that says trespassers will be prosecuted. Is that enough? Probably not. You're going to have to put a fence around it. That fence is your protection of intellectual property. So what you want to do, right? And again, make sure that your fence that you build for your IP is at the edge of your property, is at the edge of your intellectual property. If it's too narrow, if it's too close to the center, you're leaving the rest of your land for your neighbors or for trespassers or for squatters. If you build outside of your land, you are infringing on your neighbor's property. So you want to be at that sweet spot, right at the edge. Typically, as IP lawyers, what we like to do is we like to protect outside, and then, bring it, and as and when the hearing proceeds and prosecution happens, we bring it closer and closer, and then it sits at the edge of our intellectual property. So don't forget to put that fence around your intellectual property. Don't forget to evolve with the times, right? The world, and the world right now is changing at a much higher speed, much faster than it was changing, say, 20 years ago, right? For us to go from the CRT televisions to 4K, it took nearly more than 20 years, right? But to go from LED, LCD to plasma to 4K, it took like a couple of years, right? And then to go into from the idea of watching a television on a screen to watching on your iPads and on your mobiles, it happened even faster. So things are happening much faster now. We are going from, jobs where we are required to write and read a lot, to jobs where AI is going to do that for you and you can focus on other things. But let's not rely too much on AI for that. The point I'm trying to make is that don't be a dinosaur, right? Because we know what happened to the dinosaurs through no fault of theirs, of course, but if you don't evolve with the time, if you don't evolve with, say, you have to go from analog to digital or from digital to cloud, whatever it is it takes, make sure that you keep up with the times. Make sure you bring your innovation into the current times. Make sure when you're drafting or you go to an IP lawyer and they're drafting or filing for you. I was having this conversation with my partner today that we need to be able to envision what the future may bring 10 years into the future. It's not my job as an IP lawyer. It's your job as the inventor, as the entrepreneur, as the startup owner to envision what could go wrong. It may not always go follow a plan, but it's better to be prepared, right? So explain all that to your IP lawyer and help us help you on your journey, right? So you want to plan, you want to have a strategy, you want to have funds in place, you want to have a pipeline, you want to have a process in place, right? Yeah, I don't have the funds today. I agree. You're a startup. I totally agree. But have a process in place. I'm going to roll it out at this point. I'm going to have a pipeline. This is when the trademark will happen. It's a smaller investment. This is when the R&D will happen. This is when the patent protection will happen. This is when the patent protection will happen in other countries. This is when the design protection will happen. This is how I'm going to weave a narrative around it, right? And protect it. Right? If you don't take care of it, it's an assertive right. So if you don't take care of it, if you don't protect it actively, nobody else is going to do it for you. So you have to stand up for yourself and monitor all the countries and make sure that no one is infringing on your right. No one is building their fence. So I have given you a lot to think about today. What I'm going to do is now I'm opening the floor for questions. And if you have IP related questions, it may or may not have to do with the talk I gave you today, because today was more of a story session. But please, let's have a conversation. Let's have a discussion.
Felician, I'm going to answer Felician's question. If it is a brand new invention, not related to what your earlier one, you get your entire 20 years again. But if it is an improvement on the existing one and it is sort of sits on top of the existing one, then you file what is known as a patent of addition, where the life of that is like a mother and child situation, where the life of the new patent of addition is linked to the life of the original patent. So if the remaining time on this is 10 years, then you only have 10 years on your patent of addition. So there is a provision in the act for that. Do we have any other questions? It doesn't have to relate to the talk I was giving today. It could be your own IP queries. Yeah, that doesn't increase the patent term. It keeps it at what the original one was. But if it is a substantially new innovation, Felician, then we file for a fresh patent. And then at that point, you're not really worried too much about the patent term. You have an idea. You're the expert in the field as an inventor, so you have an idea of how the field is evolving, and then you get an idea of whether you want to keep it going for that long or not. Also, with patents, you have to pay a maintenance fee, renewal fee regularly, and so if it is not bringing you any kind of income, if it is not adding to your business, then it doesn't make sense to even hold on to it. Good question. Danish Kazi says, can perfume composition be protected by any way, patent or anything else? Perfume composition is a very interesting question. There were people who thought that perfume composition should be trademarked. But a trademark cannot, one of the requirements for trademark is that it cannot be indicative of goods or services. So, for example, if I'm selling tea, I cannot call it tea. If I'm selling water, I cannot call it water. But I can call electronics as Apple. I can call cosmetics or soap as Dove. So for perfume composition, it could be a copyright protection, If it is a novel composition, maybe patent, but I haven't seen any patents for perfume. Usually it is for the trademark, the brand name, and then they copyright the or they keep it as a secret, the whatever chemicals they are using. Trade secret would actually be a very good way of achieving protection for perfume composition. Because when you do, if you file a patent, you have to disclose it, right? That is the first thing. So the word patent, interestingly, it means it is the opposite of latent. Now if you remember latent heat from school, it is the hidden heat, correct? So patent is the opposite of that. You have to disclose everything to the government. You have to disclose everything to the patent office. I'm not sure you want to do that with your perfume composition, because then your competitors are going to have access to it. So definitely not patent. I would say keep it as a trade secret. I hope that helps, Danish. Any other questions? How do processes get protection? Interesting. So, so patent can protect a process as well as a product. Now, your process should not be something that is commonly known. Again, processes can go either way. If it is a process that is not known at all, and you can keep it under lock and key, and only have a handful of people know about it, then by all means keep it a trade secret. But if it is a process that is commonly known, but you have an inventive step in it, you have created an invention, an innovation in it, either by changing one of the steps or by adding your own inventive feature to it, then you can patent it. Trade secret. So for example, Coca-Cola, their recipe is a trade secret, right? I don't know, obviously they've not patented it, but I don't know if it is the process or it is the ingredient. I don't know what is the trade secret. So Felician says, how relevant is patent trademark in food industry? Extremely important. Extremely important, right? If you look at the food industry, most of the entire FMCG sector is dominated by trademarks. That's why you have a Good Day, you have an Oreo, you have Britannia, you have a Marico, you have Lotus biscuits, and all of these things, right? The entire FMCG section is trademark related, but it also is patent related, right? There are methods. They have patented method of making soup, soup recipes. They have patented recipe for cakes, and they have trade secreted the recipe for Coca-Cola and KFC. Some of it is patented. So you can go to every FMCG company and find what their portfolio of trademark and patent contains. Largely trademark related, but you will find patents, smattering of patents as well there. So it is relevant, and it is actually relevant in every industry. But since you asked for food related, then yes, especially. But today there are so many questions about the ingredients used in Coca-Cola. Are trade secrets a way for F&B or any cosmetic company to push out unhealthy products? Yes, but it is not. That's not always the motive behind keeping something a trade secret, right? Sometimes it is purely business oriented, purely revenue and cash flow driven reason. It's not malicious, but yes, if you want to look at it, if you want to challenge it, you can challenge it, and the proceedings are usually held in camera. That means in a closed room, and the judge will then rule about it, of course, without divulging what the trade secret is. So it's not always that they have a malicious intent in mind, but you can always challenge it. Can you guide on the
initial documentation and evidence required to support patent application? How do we begin if we are looking to take a patent? What is that? Patent for a product. Okay. In this short period, if you go to any IP lawyer, they are going to give you what is known as an invention disclosure form, and you fill out the invention disclosure form. To the it usually it's a question of what is the background. So if I want to say, let's say, I've patented this cup that keeps the tea warm, right? So the first section is background. What are the existing kinds of containers for liquids, right? What is the problem with them? Right? There's a problem. That is why you have a solution. So what is the problem with the existing containers for liquid, with the existing cups? What are people using? And now there is a problem with that. So that the solution to that problem is your product. Then that's how you begin explaining. And then you say that there are these patents, and this is the problem with all of them. If you don't have the wherewithal to find those, your patent attorney will do a search for you. And then you bring in your invention, explain all the details. Before you divulge anything, please make sure that you sign an NDA. Please sign a confidentiality or a non-disclosure agreement with your patent attorney, with anyone else you're divulging your IP to. Do not divulge and then say, now what do I do to protect it? Right? Once you divulge, it's public domain. You can't do anything about it. You cannot divulge and then hope and pray that the other guy is conscientious. It doesn't happen. Doesn't work. So then you explain what your invention is, give whatever drawings they need, give whatever pictures, images, flowcharts, whatever they need. They will draft a document and give it to you for your approval. You okay it. Typically, your filing fees, the government fees, for an individual inventor or a startup or an educational institution is about 12 to 15,000. This is only government fees. For your attorney fees, you'll have to check with your attorney. If you're a large corporation, you're looking at government fees of about 25 to 30,000 rupees. And then, of course, once the patent is granted, your renewal and maintenance fees kick in. So your initial documentation, I would say, is what is the existing technology in that area, and what is the problem with that, and how is your invention filling that gap, and describe your invention in very minute, very excruciating details. Because think of it this way, Aparna, is that you are the expert in your field, and if you come to me for me to file a patent for you, you have to be the expert and teach me, talk to me as if I'm in 5th standard, and disclose your invention to me as if you're explaining it to someone in 5th standard, and then I can put it in words that the patent officer, the controller, is going to understand your invention. So I will convert it to legal. I hope that helps. Lots of Aparnas here today. On the topic of divulgence, several startups make their pitches and tend to disclose sensitive information that may be related to their IP. How can this be handled? Aparna, can you qualify your question with how can it be handled? How can you train them to not disclose their IP? Or how can it be handled once they have disclosed their IP? Can you give me an explanation for that? If it is already disclosed, then unfortunately nothing can be done. But if you want to give your pitch without disclosing your IP, there are ways of doing it.
You talk about how your invention solves the problem rather than what your invention actually is, right? The person you're pitching to, a room full of investors, a room full of angel investors or VCs, they may not be well versed in technology. They may not be from your technical domain either. So you don't have to sit and explain nuts and bolts of your invention to them. What you can fixing that gap. This is how, when a plumber comes to your house and your sink is leaking or your faucet is leaking, you don't need to know how he's fixed that leak. You need to know that there was a leak and he's fixed it. He doesn't give you a breakdown of how he's fixed the leak. He just brings his toolbox, goes under the sink, tightens something, does, I don't know what he does under there. When he comes out, the leak is fixed. And that's all you need to know. Right? So that's all the your audience needs to know. I hope that helped, Aparna Rao. Is the pitch considered a disclosure? Absolutely. Absolutely. You still have 12 months within that, at least according to US laws. If you disclose something somewhere, or you have, let's say you've devised something for public use, a traffic signal or something, and you release it, you have 12 months. You have published something, you have 12 months within which you can protect it. But it can go either way, because in so if it's publishing, or if I've put it out given to PWD or something, it's a different story. But in a room where I'm pitching, there are other people who think like I do. There are other founders, there are investors who have portfolio companies. You don't know what they're going to do with with the information. So it's better to be safe than be sorry. um, Talk about how you're bridging the gap, rather than how you're doing it. What about NDA before making the pitch? Is it an established practice? Teresa, NDA in my experience doesn't work, uh, because you are not in the position of power. You're not in the position to negotiate. It is the VCs or the people who are listening to your pitch who have the upper hand. So when you go in, asking them to sign an NDA is kind of like a slap in the face, and most get offended when you ask them to sign an NDA. They'll just get up and walk away. I have known people who say they do that. Secondly, an NDA has no teeth. It has no clause. So for you to go and enforce it in a court of law is going to be extremely difficult. So an NDA can work with your employees and your business partners. It will not work with someone who is higher up above you. Whoever is in the position of power gives the NDA, not who is going looking for help. Better to have, Aparna says, better to have closed door pitches and not disclose the details like you suggested. Yeah, I think that's the best bet. Only once they have signed something and once you have entered into a relationship with them, then you go and disclose it. But at the first initial meetup, there is no need to divulge the nuts and bolts of your invention. Unless, of course, it is like a t-shirt on which you're printing stuff, things that are already known. But if it is something like this technology for keeping the liquid warm in this cup, by the way, the liquid doesn't stay warm in this cup, it's a regular ceramic mug, but it's a good example to have. So the technology for how I keep the liquid warm in this ceramic cup, uh, it could be, I don't need to divulge it to you. I just need to tell you that, look, currently there are a lot of people on online meetings, and and they sit with their tea and coffee mugs, and the tea and coffee grows cold, so there is a way of keeping it hot in this open ceramic mug, right? They don't need to know what the technology is. Yes. There have been a lot of conversations on LinkedIn on this topic of NDA, getting VCs and angel investors to sign an NDA. And uh, I also host a podcast where I talk to them, and they usually say that they do not they're not open to signing NDAs. And I had an angel investor talking to me to invest in me, and uh, at one point I realized whatever he was talking to me, he was using information from me and giving to his portfolio companies where he's already invested in by falsely promising me stuff. Thankfully, we were in very different industries, so he couldn't take anything from me and pass it on. But it happens, so you want to be careful. Any other questions? I would also appreciate feedback on whether you found the session helpful. Um, it could have been, it could have gone either way in terms of being extremely technical and legal intensive, and you would have gotten bored. And that's why I try to keep it at a story level and learnings from it. Which, if you the legal and technical part, of course, you all are experts. For the legal part, you'll go to your IP lawyer and you'll get feedback and you'll get guidance. But the strategy part is something that you can do for yourself. You can think for yourself. Okay, what happens if you explain the process, how your invention platform works by hiding the technical flow? Uh, the Now, Smitish, the question is the process or how my platform works, is that um, is that part of my inventive step? Is that something that I'm trying to protect? Because if it is, then divulging it will not make any sense. You can explain the process. Can you explain the process without giving up any part of what actually is protected in your patent or in your trade secret? No, I didn't understand your question. Can you please explain your question, Smitish? Is this with the patent office, or are we still talking about the investors and pitching sessions? Okay, I guess I answered his question. More questions? Felician is sharing my organization handle for LinkedIn and also my personal LinkedIn profile. Any other questions? On anything IP related. I also do valuation and monetization of IP. So if you have any valuation of IP or valuation of business related questions, you can ask that here. I also provide technical and IP due diligence services to investors. So you can ask me what they're looking for or what those things comprise of. I provide ultimately I provide end-to-end IP services. So if you have any questions on, and I do a lot of sessions on those as well. So if you have any questions on valuation, um, uh, tech and IP due diligence, what are people looking for? I'm happy to answer. Thank you. Y'all have been a fantastic audience. I love the question answers. It was a pleasure engaging with you. All the best on your entrepreneurial journey.